Basics of the Canadian government and legal system. Canada's government is a constitutional monarchy, where the role of the Queen is largely ceremonial, and real political power resides in the elected Parliament. The political structure of Canada is bicameral, consisting of the House of Commons and the Senate. Canada's government is also characterized by its federal system, dividing powers between the federal government and the provinces. This division of powers is crucial for understanding how privacy laws apply and operate differently across provinces. The role of courts and administrative tribunals in Canada is fundamental. Courts interpret and enforce laws, including those related to privacy, while administrative tribunals often handle specific disputes like those involving privacy breaches under certain circumstances. Canadian laws and their interpretations. In Canada, laws originate from two primary sources: statute law, laws passed by legislatures, and common law, laws developed through court decisions. The distinction between civil law, predominantly in Quebec, and common law, in the rest of Canada, is significant for privacy regulations as each legal tradition approaches privacy from slightly different philosophical and procedural standpoints. Understanding these differences is crucial for professionals dealing with privacy across provincial lines. Roles of privacy commissioners and remedies. Privacy commissioners in Canada play a pivotal role at both federal and provincial levels. They oversee the application of privacy laws, investigate complaints, and provide guidelines on best practices for privacy protection. The courts, on the other hand, provide remedies for privacy violations, which can include compensation for damages or orders to change practices that violate privacy. IB applying privacy basics. Variations in definitions of personal information. In Canada, the definition of personal information can vary significantly between jurisdictions and specific pieces of legislation. It is critical to understand these variations, especially when handling data that may fall under multiple regulatory frameworks. For example, employee information may be treated differently in privacy terms compared to consumer data. Private and sensitive information. Understanding what constitutes private or sensitive information is foundational. This includes recognizing various categories of personal information, such as financial, health, or personal identifiers, and knowing the enhanced obligations for handling such data. Safeguarding personal information. Professionals must be well versed in the standards and frameworks for safeguarding personal information. This encompasses a variety of controls applicable to third parties, the use of privacy-enhancing technologies, and an awareness of cybersecurity issues. The technological landscape constantly evolves, and so do the threats to personal information, necessitating ongoing vigilance and adaptation. Privacy incidents and reporting obligations. Handling privacy incidents and breaches requires a structured approach, including a clear understanding of the notification processes to the Privacy Commissioner and other relevant authorities. The legislation often dictates specific obligations depending on the sector and the nature of the data involved. IC understanding the development of privacy principles. Fair information practices. The development and application of fair information practices are central to privacy management. These practices include principles such as providing notice to individuals about data collection, implementing access controls, and ensuring accountability for data handling practices. International guidelines and standards. Knowledge of international standards, like the OECD Guidelines on the Protection of Privacy and the Canadian Standards Association (CSA) Model Code, is essential. These guidelines provide a framework that influences both policy development and operational practices within organizations. Additionally, the Generally Accepted Privacy Principles (GAP) offer a comprehensive set of practices that help in the governance, management, and compliance of personal information. ID International Privacy and Implementation. The impact of international and regional laws on Canadian organizations cannot be underestimated, particularly in an era of globalization where data frequently crosses borders. Understanding these laws is crucial for organizations that operate internationally or that handle data from non-Canadian entities. Data transfers across borders. Data transfers across international borders are a complex issue under privacy laws. Canadian organizations must ensure they comply with applicable standards that might include mechanisms such as adequacy decisions, which confirm that the data protection level in another country is acceptable according to Canadian standards. This is particularly relevant in sectors like healthcare, education, and finance, where data sensitivity might necessitate additional safeguards. Applicable adequacy standards. The European Union's General Data Protection Regulation, GDPR, and its framework for data transfers outside the EU significantly influenced Canadian practices. Canada's adequacy status under the GDPR allows for easier data flow from the EU to Canada, but maintaining this status requires ongoing compliance with these high standards. Organizations must be vigilant about changes in both Canadian and international privacy regulations to ensure continuous compliance. Sector-specific considerations. Different sectors may face unique privacy challenges and regulatory requirements. For example, healthcare. Privacy concerns in healthcare are paramount due to the sensitive nature of health information. Canadian organizations must comply with specific provincial and federal laws regarding the handling of health data, which often provide stricter controls than those applied to other types of personal data. Education. Educational institutions handle a significant amount of personal information about students and staff. They must navigate a complex landscape of privacy laws that protect children's data, particularly in online environments. Finance. The financial sector is heavily regulated with regard to privacy, given the sensitivity and commercial value of financial information. Canadian financial institutions must adhere to specific privacy standards and practices to protect customer data from breaches and misuse. Conclusion. Understanding the intricacies of privacy within Canada's legal and political framework is essential for privacy professionals. This includes a thorough knowledge of governmental structures, legal interpretations, and the specific roles and powers of privacy commissioners and courts. Moreover, applying privacy basics across varying jurisdictions, safeguarding sensitive information, and managing privacy incidents are fundamental competencies. Additionally, being cognizant of the development of privacy principles and the impact of international privacy laws ensures that organizations can not only comply with current regulations but also anticipate and prepare for future challenges in privacy management.